Hello, everyone. Good morning, good afternoon, good evening to all of you. It's wonderful to see so many participants on this webinar today. Thank you very much for joining this webinar to provide you with an update on the BEPS Action 6 peer review process. So I think we are quite familiar to some of you, maybe less familiar to others. So it seemed an opportune time for us to provide this information to you on the process regarding the Action 6 minimum standard and the peer review process that goes along with that. I would encourage you, although we've got a good number of people on this Zoom call, I would encourage you all to participate actively in this session. We've got some very, very good presenters who will be taking you through the session, and I'm sure they will be very happy to answer any questions that you might have. So please don't feel shy or feel worried about asking questions. This is a great opportunity for you to interact both with the OECD Secretariat and with a whole range of your peers from around the inclusive framework. Equally, if you think of a question after this session, when you go back to your desks and are thinking about how this process applies to your country, and a further question occurs to you that perhaps you didn't think of during the session, we are of course very, very happy to interact with you and to help you with any questions or queries that you might have. So please do feel free to get in touch with us after the session as well. We're always happy to help, not just on Action 6, of course, but on any of the BEPS actions that you might be implementing in your country. If you've got queries, if you've got questions, if you've got feedback for us, we're very, very happy to enter into discussions with you about any of those matters. So with that very brief introduction, once again, welcome to all of you. And I will hand over to the team now. So back to Nestor, Andrew, and Sarah to take us through today's session. Thanks very much.
My name is Nestor Venegas. I am part of the Tax Treaty Unit of the OECD Secretariat, and together with Sarah Shermour, also a member of the Tax Treaty Unit, and Andrew Dawson, an experienced former negotiator of tax treaties and member of the Tax Treaty Unit as well, will lead you through the different topics that we will analyze today. We have organized the agenda in two big blocks, Session A and Session B. The first session will provide you with a general overview of some essential concepts that you need to understand before working on the questionnaire. The second session that will be led by Sarah, it will be more practical, more focused on the new features of the questionnaire to complete the first stage of the peer review process. I'm pretty sure that some of you registered to this webinar with trying to find out to be better prepared for that work. So Sarah will lead that session, and Andrew and I will lead Session A, which I will show you a little bit the agenda. Let's share with you the screen. Okay, so that's the agenda in front of us. So Session A will explain a little bit the general context of this peer review process, which is the BEPS project, of course, and Action 6 in particular. So that in Session B, we will focus mostly on the completing the questionnaire, and we will have some examples on some practical exercises. As Melinda said, you are very welcome to ask questions. For that, we will be checking the chat function mostly. So you can write down your questions there, and we will address the questions in those question and answer sessions that we will have immediately after each of the sessions. Okay, so first, Session A will provide you, as I explained, with a context, with some context. Where are we located in the BEPS map, the BEPS project? Where is this Action 6 peer review process located? We will explain what's the minimum standard, what are the provisions and alternatives to meet this minimum standard, what is the purpose of this minimum standard, what are the terms of the commitment that made by members of the inclusive framework. We will discuss different methods for implementation of the minimum standard. And finally, we will give you in this session an overview of the peer review process in general. So Andrew Dawson, please, you're welcome to start.
Thank you, Nestor, and hello everybody. Welcome to this seminar. As Nestor said, what we wanted to do was to give you a mixture of background and context, as well as some really practical help in filling in the questionnaire. But before and Sarah will, in part B of the program, Sarah will be in charge of that. But we wanted to just set the scene a bit to remind people who were around at the time, because it was quite a long time ago when all this began, and for the benefit of those people who are sort of new to this, how it all fits together. Now, we're going to focus on Action 6, of course, but Action 6 was just one of the 15 BEPS actions that was put in place in 2013. And in 2015, at the end of a sort of a 2-year process or a bit more, there were 15 reports on different aspects of BEPS. Now, there are various ways you can analyze these reports or group them, and this is one attempt that was made at the time. It's a little bit arbitrary, but you could see as we've color-coded them, some grouping into actions that address coherence, actions that were on substance, and actions that were on sort of transparency. And if you look at the right-hand column, you have the digital economy, which is a sort of a cross-cutting issue. And during the BEPS program proper, as it were, between 2013 and 2015, a lot of work was done, and a big, thick action report was produced, but there weren't really very many conclusions that emerged from that, apart from perhaps some sort of negative ones, that there was nothing that we were going to do for the time being. And of course, the action on the digital economy is what's occupying us very much now, but I'm not going to say anything more about that. So I'm going to be talking mainly about Action 6 and preventing treaty abuse. I'm going to be talking about the way the Action 6 calls for the creation of a common statement against treaty shopping, which will often appear in the preamble to the treaty. I'm going to be, well, Nestor and I are going to be talking about the principal purpose test and the limitation on benefits rule. And these are different ways which we will explain of meeting the minimum standard. But just to run very quickly through some of those other things on the list, Action 6 was quite a wide-ranging project, I suppose. And there are other things apart from those 3 things. For example, we've got the company residence tiebreaker, which is part of Action 6, which was a sort of anti-abuse rule, because if companies were deliberately choosing to be dual resident in order to improve their treaty position, then the company residence tiebreaker rule was designed to defeat that. There are specific rules on dividend transfer transactions to introduce a 365-day test in Article 10, which was a holding period. You had to hold the shares for a longer period in order to take advantage of the reduced rates in Article 10. Also, there was a 365-day test introduced into the capital gains article, operated slightly differently, but again, it was to stop. Well, briefly, it was to stop companies sort of flooding a vehicle with cash in order to circumvent that test. There was what's called a third state PE rule, which is designed to make sure that tax was paid in certain combinations of exemption systems. And there was what's called a saving clause, which was enshrine the right to tax your own residents, because with certain important exceptions, treaties do not affect the right of a country to tax its own residents. And so that was put in place. So that was sort of the kind of a snapshot of the Action 6 stuff. very briefly on Action 14, that's about dispute resolution. Many of you will know there's a whole separate minimum standard on and peer review on Action 14. Many of you will be involved in that. This is about essentially about the MAP process, how to improve the MAP process, the mutual agreement process in treaties. And I'm not going to say anything more about that. Action 7, the artificial avoidance of PE status. That's something that was a large project in its own right within the BEPS portfolio, and the changes that are available in Article 7 are available to be implemented through the MLI, the multilateral instrument, which Nestor will say something more about that. So I'm not going to say anything more about Action 7, excuse me, for the time being. And then finally, Action 2. This was not something that Working Party 1, the Treaty Working Party, was very much involved with. It was carried out elsewhere, but there were some actions, particularly directed at treaties, and in particular, there was a provision on transparent entities, which was designed to make sure that the provisions of the OECD Partnership Report, the 1999 Partnership Report, were properly implemented in tax treaties to make sure that that through these use of hybrid mismatch arrangements, tax was not avoided. So that's all I wanted to say about that. So if we could go to the next slide. If you want to get further details, because my summary was as brief as I could make it, then here are the different action final reports 2015. So you can read them. They're all available. They're all available to members of the Inclusive Framework, free of charge on the OECD website. And if you can't face reading these documents, then there are other courses we have available to look in more detail at this. So that's, again, something that we can do. Thanks, Nestor.
Yeah, just to let you know, Andrew, I added on the final slide with a calendar of events for 2021 as a surprise, last minute surprise.
Did you?
Yeah. To advertise a little bit those classes and virtual courses that you are mentioning.
Good, thank you. Okay, next slide. So the Action 6 minimum standard. What is it? It's a minimum standard, which means that everybody has signed up, all members of the IF have signed up to implement the Action 6 minimum standard. And the peer review, and we'll explain why it's necessary to have a peer review, is to make sure that the minimum standard is implemented across treaties, subject to a certain caveats that I will mention in a moment. And all IF members participate in the peer review on an equal footing. So what is the Action 6 minimum standard? Well, there are essentially two parts of it. The first is an express statement in the preamble, and we will look at that in the next slide, which explains that that treaty shopping is not something that treaties are put in place to achieve. And the other element of the minimum standard is that countries have to, or I should say jurisdictions, have to introduce anti-treaty shopping provisions in one of these forms. It can be the principal purpose test, and we'll explain what this is in a moment, together with the limitation on benefits rule in either form, the simplified or the detailed. And Nestor is going to be explaining about the limitation on benefits. So that's one approach you can have. You can have the PPT together with the limitation on benefits rule. And you might want to do that because you want, for example, the limitation on benefits rule might sort of filter out the worst cases of treaty shopping, allowing you to apply then the principal purpose test to certain, say, more difficult situations, or indeed situations that the limitation on benefits rule is not designed to apply to. Or if you don't want to do that, you can go for the principal purpose test on its own. Or if you don't want to do that, you can have the detailed LOB together with an anti-conduit arrangement rule. And the reason you need to do that is that the limitation on benefits article does not apply to all types of treaty shopping. And as Nestor will explain, yes, it adopts quite a different approach. So if we could go to the next slide, Nestor, please. Now, the minimum standard is, you could think of it as in sort of two parts. You could think of it as having an objective element, and that's the things I was trying to describe a moment ago, the principal purpose test, the limitation on benefits article, the preamble. So those are the kind of objective elements. But there are some, there are these sort of four kind of caveats, if you like, that you're only required to implement the minimum standard if requested to do so by another member of the inclusive framework. Also, the means of implementing the minimum standard, whether it be the LOB or the PPT, has to be agreed bilaterally, assuming it's a bilateral treaty. In other words, you can't come along and say, I demand to use the PPT or I demand to use the LOB. It's got to be agreed. And the commitment you make to introduce the minimum standard is not a commitment to conclude or amend treaties within a specified period of time, or briefly stated, there are no formal explicit time limits in which within which the minimum standards have to be put into place. Now, why is that? Well, the answer is that negotiating a treaty can be a very complex and drawn out process, particularly if you're trying to introduce other features into the treaty at the same time. You may be opening up a treaty not just to put in the minimum standard on treaty shopping, but you may be trying to do something else as well. You might be trying to look at some of the other BEPS actions, for example, on permanent establishment, which I very briefly mentioned earlier on. And that might take a long time because it's, as I say, there are lots of BEPS changes that are not minimum standards, so you might spend time arguing about those, or just in general, it might take a long time to do so. Also, there's no obligation to protect your own source state taxing rights. Now, remember how treaties work. They operate by essentially giving up source state taxing rights, whether that's in whole or in part, or where it doesn't, or there are some cases where there is no giving up of source state taxing rights. For example, where there's a permanent establishment in your jurisdiction, you don't give up source state taxing rights there. But on the whole, it's the source state that's giving up its taxing rights, particularly in the passive income articles, dividends, interest, and royalties. And that's where treaty shopping is most likely to be an issue. So if you're not bothered about your source state taxing right, that could be because, for example, you're one of those jurisdictions that simply doesn't have any source state taxing rights under its domestic law, under outbound dividends, interest, or royalties. If you're in that position, or for whatever reason you just you don't regard this particular treaty as a concern, then you're not obliged to put in a provision that protects you. What you are obliged to do is, if the treaty partner comes to you and says that they want a provision, then what you can do is you can put, and this is very rare, I have to say, I've hardly ever seen this, but you can put in a provision which is not a reciprocal provision. So you allow the treaty partner to protect itself against treaty shopping, but if you choose not to do so, then you don't have to. Okay, let's move to the next question. Next slide. So what is this express statement of this common intention? It doesn't have to be in the preamble, but it almost certainly is going to be in the preamble. And what it says here is, I'll just read it on the screen, that the two states intending to eliminate double taxation, and that's always what treaties have been about. I mean, they are double taxation treaties. But this is the important bit in purple: without creating opportunities for non-taxation or reduced taxation through tax evasion or avoidance, including through treaty shopping arrangements. Now you may say, well, this is all very vague. It doesn't really do anything. It's not an operative provision of the agreement itself. Why have we bothered doing this? And the answer is it's to set the context in which the treaty will be read. In terms of the Vienna Convention, for example, when you're just trying to interpret, if a court's trying to interpret the treaty, this will point the court's attention to the undesirability of treaty shopping arrangements. So it should not be open to a judge to say, well, I see this is treaty shopping, but so far as I can see, the treaty says it's okay. This is saying, no, it's not okay. And there's a tie-in between the treaty shopping here and the way that the principal purpose test works. So it's here to bolster the other anti-avoidance elements of the convention. So this is the new preamble, the express statement of common intention, which is part of the minimum standard. Must do this. Next slide. And here is the principal purpose test. It's rather like a general anti-avoidance provision, and many of you will have sort of perhaps seen things maybe in your domestic law that uses a purpose test in order to counteract treaty shopping. It's not a mechanical test. It's not a kind of a black line test. It doesn't have numbers in. It doesn't have ratios in. It doesn't have thresholds in. It says a benefit shall not be granted if it's reasonable to conclude that, having regard to all relevant facts and circumstances, obtaining the treaty benefit was one of the principal purposes of any arrangement or transaction. But there's an important bit at the end, unless it's established that granting the benefit would be in accordance with the object and purpose of the relevant provisions. Because clearly the treaty is there to be used. It offers companies and individuals benefits if they do certain things. So we want people to operate in certain ways, and the treaty will sort of reward them if they do so. But if it's reasonable to conclude that one of the principal purposes was to get the treaty benefits and not, for example, some other sort of bona fide purpose, though it deliberately doesn't say that, then the benefit is taken away. So that's the principal purpose test. That's the one of the other elements of the minimum standard. Okay, thanks, Nestor.
Just to supplement what you said, Andrew, and on the PPT, we have to bear in mind as well that there is this final part, like unless it is established that granting the benefit of these circumstances will be in accordance with the object and purpose of the relevant provision of this agreement. So it is not enough to have a transaction or arrangement that has one of the principal purposes obtaining treaty benefits, but that purpose should be against the object and purpose of the treaty. So sometimes you may have situations where the transaction, of course, took into account the obtaining treaty benefits, but as long as there are, for example, there is substance and a real economic transaction behind the arrangement, that could be totally in accordance with the object and purpose of the relevant provisions of the treaty. So that's important that we don't simply apply the PPT. It's a very powerful tool, very powerful anti-abuse provision, but it should be used with carefully used, because it's a kind of atomic bomb. You don't want to use it discretionarily. So let's go to
thanks for making that point there. So I think that is a really important point.
So limitation of benefit provision, LOB. I already see one question in relation to the combination of PPTs and a detailed LOB. And I personally think the combination of PPT and a detailed LOB will give you the most, I would say, the highest level of protection to your treaty. And that would be one of the alternative ways of meeting the second component of the minimum standard, of course. But let's give you let's understand a little bit what a limitation of benefit provision is. So basically, this is a provision that is, the purpose of this provision is to ensure that the residents of either contracting state are not only resident because they are holding a certificate of resident, but they have a real nexus and connection with the country or jurisdiction they are saying they are claiming residence. So it's not enough to be resident. When you have a limitation of benefit provision, you need to comply with additional conditions. You need to pass one of a number of tests, at least one of them, okay? Let's have a look. You have two versions of this provision. You have a detailed LOB provision and a simplified version of the LOB provision, SLOB. Both are recognized in the 2017 version of the OECD model in Article 29, paragraph 1 to 7. You have this is a very particular way of presenting a model provision because it provides you a structure, but the substance of each paragraph of this provision, it's really explained in more detail in the commentary of Article 29. So I invite you to read the commentary there. Of course, when you approach for the first time an LOB provision, you may find it very scary. It's a long provision with many paragraphs, many complex descriptions of elements and conditions. But once you understand what the purpose of the limitation of benefit provision is and how it operates, it's much easier to apply and to understand it. So you can also find one option to implement this limitation of benefit provision is offered by the MLI, the multilateral instrument. I will explain later, give you an overview of the multilateral instrument, but it's good for you to know that under Article 7, paragraph 8 to 13 of the MLI, you have a simplified version of the LOB. The MLI does not offer a detailed version of the LOB, just the simplified one, because the detailed version contains certain elements and conditions that were not very suitable for the multilateral context. So only the simplified LOB provision is offered by the MLI. So let's use an analogy to explain and to understand how a limitation of benefit provision works. And I use this analogy of the doors. So let's imagine that you could be a person, either an individual or an entity. You are holding a certificate of residence of one of the contracting states, and then therefore you want to obtain treaty benefits. And normally, without a limitation of benefit provision, that would entitle you to obtain these treaty benefits. However, if the treaty includes a limitation of benefit provision, that is not enough. You will need to be a qualified person, or in other words, to be able to cross at least one of these tests, one of these doors that you need to cross in order to obtain treaty benefits. So there are like 6 doors, 6 filters, 6 tests, very descriptive, very objective tests that will apply to the person, either an entity or an individual, for them to qualify for treaty benefits. So for example, the first door, and this slide here tells you where to find this door in the simplified limitation of benefit provision in the MLI for you to further analyze this provision. So the first door, for example, you can get through the door, you can open the door if you are listed as a qualified person, or for example, individuals. Individuals are normally listed as qualified person. They can open the first door. The second door, for example, is open for publicly traded entities, companies that are traded in a recognized stock exchange, because there is a sort of assumption that those entities are real, they have substance, they are highly regulated, so they are trusted, and a publicly traded entity is able to cross through the second door. The third door, for example, the third test would be for companies that comply with certain minimum local ownership tests. If your owners as an entity, your partners, your shareholders, all of them qualifies under the LOB, for example, if they are individuals residents in the contracting state where you are holding the certificate of residence, you can cross this door. The fourth door is a bit more complex. It's called the equivalent beneficiary test. And this is applicable for those entities that were not able to open any of the previous doors, but their owners, the entities that owns or persons that owns this entity, even if they are located in third states, if they would have made the investment or the transaction directly from those 30 states, if they would have been entitled to similar or even better benefits compared to the ones that would be entitled the entity itself. The fifth door, or test is the active business. So of course, even if you are an entity, a company, let's say resident in one state, but all your partners, all your shareholders, the owners of this entity are located in a third state, so they didn't comply with any of the previous tests, you can still obtain treaty benefits if you prove that you are carrying out active business activity and your business is substantial regarding in the resident state compared to the business that you are carrying out in the other state, in the source state in this case. Of course, for those borderline cases, you have a little bit more subjective test, a final door, which is basically the permission, the special authorization by the competent authority of the source state. That is the way how a limitation of benefit provision works. So when you face the article, don't be scared. Think about the doors. Think about that an entity or a person doesn't need to comply with all the tests, but just with one, and it will be entitled to enter the benefits of the convention in particular. How this provision interacts with the principal purpose test? Well, you can still be kicked out of the party, even if you were able to cross one of these doors, by the application of the principal purpose test. We discussed, I remember when we were analyzing this Action 6, preparing the Action 6 report. I remember I was delegate for Chile by then. I remember we discussed some cases that the LOB would not cover, some cases of treaty shopping, very limited cases, but still some, for example, conduit arrangement. But the PPT would address those issues anyway. So let's continue. Methods for implementing this minimum standard, different components, different combinations that are possible. Of course, you can bilaterally negotiate the inclusion of these provisions in your treaties. And that would be perhaps the most feasible way to do it if your treaty network is reduced. If you have, let's say, 2 or 3 treaties, perhaps it's better for you to start renegotiating them. But in cases where countries have a broader treaty network, more than 80, I don't know, like the UK, for example, it would be very time-consuming and resource-intensive to renegotiate all those treaties. So the multilateral instrument would be a more efficient way of implementing at least the minimum standard. And also, as Andrew already mentioned, the multilateral instrument will allow you to incorporate other tax treaty related measures resulting from the BEPS project. But anyway, the message is that you have to bear in mind that the MLI is not mandatory. It's an option to save some time and resources renegotiating treaties, but you can always renegotiate your treaties and include the comply with the minimum standard by doing so. So some background about the MLI, the multilateral instrument, which is, I think, very important to understand in preparation for completing the questionnaire. So the Action 15 of the BEPS project analyzes and reflects the analysis from international law experts on different options to implement the tax treaty related measures resulting from the BEPS project. One option, as I mentioned, which is still there, it's bilateral renegotiations. Okay, it's still possible to bilaterally renegotiate. Another option that was analyzed was to have a model protocol that every country, all the countries can follow when renegotiating the treaties. And finally, the third option that was analyzed by this group of experts was to develop a multilateral treaty, to negotiate multilaterally a treaty that will modify bilateral tax treaties in a synchronized way and consistent way. This was the mechanism, the method that was recommended at the end as a result of this Action 15. So in February, I think it was in February, 2015, the G20 mandated the creation of an ad hoc group that with more than 100 countries that would negotiate this multilateral treaty to sit on top and to modify bilateral tax treaties in a consistent way and synchronized way. So what are the key features of the MLI? First, It was negotiated multilaterally, of course, by more than 100 countries, and the English and French texts are the authentic one. However, if you check in the OECD website relating to the MLI, you will find that many countries have contributed with unofficial versions, translations of the MLI into Spanish, Japanese, Italian, German, Dutch, etc. So you can find those versions and translations there. The main purpose of the MLI is to modify the application of thousands of existing tax treaties. Okay, in terms of numbers, nowadays, if all the signatories of the MLI ratify, let's say this year, I think next year we will have more than 1,800 treaties modified or affected by the MLI. Currently, or by July this year, we are expecting that 680 treaties will be modified. So, and we still have 900 treaties waiting agreements, which means that only one of the parties in those agreements have signed or ratified the MLI, and those treaties are waiting for the other contracting jurisdictions to sign or ratify the MLI at some point. And therefore, we can reach that 3,000 treaties that we mentioned in the previous slide. It's important, as this is a complex treaty with a mechanic that it works, but it's complex and you need to study it and understand it. It's important that the treaty contains some elements to provide clarity, more certainty, and some transparency as well. And for that purpose, you find in each substantive provision of the MLI a final paragraph normally, which contains certain notifications that are required. So contracting jurisdictions that are parties to the MLI need to notify and say exactly what provisions of the bilateral treaty will be modified by the MLI and in what terms in general. Also, the MLI, when it was adopted in November 2016, November 2016, it was adopted together with an explanatory statement where you can find more explanations about the mechanics of the MLI and the interaction with bilateral treaties. It's important to know that the substance of the provisions offered by the MLI, the anti-abuse provisions in the MLI, are in the reports of Action 6, 2, Action 14, and Action 7, but the explanation about the mechanics of the MLI are in the explanatory statement. Sarah, would you like to say something? No? Or you were doing some? No? Okay. I thought you were raising your hand. So, and also the Secretariat, the OECD Secretariat, who is the depository of the MLI, has developed a number of tools that are very useful. For example, the matching database, to find out in advance what will be the results, the matching results with your position, your country's position, and your other contracting jurisdictions' position, to find out whether the MLI will modify your treaty or not. I will explain to you later in more detail what are the conditions for the MLI to modify bilateral tax treaties, which is important for you to understand. Finally, the MLI could have been a very rigid instrument, right? Offering these 10 provisions, and if you like it, you sign and you will include them all. And if you don't like one, you don't have any option. But of course, that would have been a very inefficient way of encouraging countries to sign the MLI and to adapt the different tax treaty policies they may have and the different languages they may have and variations of in their provisions in the bilateral treaties. So the MLI contains certain elements of flexibility. For example, it allows you certain reservations. It allows countries to make certain reservations, mostly against the provisions that are non-minimum standard, but even minimum standard provisions, under certain conditions, you can opt out of those provisions and comply with the minimum standard in a different way. For example, the MLI does not offer a detailed LOB provision, and some countries may prefer to comply with the minimum standard by having a detailed LOB provision, in addition, in combination with some anti-conduit rules that may have in the treaty or in the domestic legislation or judicial doctrine even. So you can still have some alternative to comply with the minimum standard, as we have been highlighting in this presentation. Also, you have optional provision, alternative provisions in the MLI. All of that, you can decide opting in, opting out. You can express the country's will and wishing list in what is called the MLI position, country's MLI position. That in that document, each country is free to make the reservations, notifications, and options that they are allowed to do. This is an overview of the structure of the MLI. Part 2 to Part 5 follows the same order of the reports. Let's say Part 2 regarding hybrid mismatches. The source of those substantive provision comes from Action 2, the second chapter. Part 3 mostly is where you will find most of the provisions resulting from Action 6 report. Part 4 includes all the provisions resulting from Action 7 of the BEPS project. And Part 5, you will find the mutual agreement procedure articles and other regarding the corresponding adjustments in transfer pricing adjustments. And finally, Part 6, you will find a mutual agreement procedure that could end up in mandatory binding arbitration. And that was the only part that was developed by the ad hoc group on the MLI in parallel by a subgroup there. And so the substance of that, you will find the substantive explanation of the arbitration in the explanatory statement of the MLI. Okay, so I think the general conditions, this is the final slide for me. How do we find out if a particular tax treaty between jurisdiction X and jurisdiction Y will be modified by the MLI? So that is you have to find out whether this treaty will be modified by the MLI and when, of course. The first condition that you need to find out if it is met or not is that X and Y have signed and ratified the MLI, and that the MLI has entered into force with regard to both jurisdictions, in according to the rules for entering into force of the MLI, the final part of the MLI. That's the basic condition. So if you are from a country, your country has signed the MLI, but some of your contracting partners or treaty partners has not signed or ratified the MLI yet, that is very unlikely. You will not modify that treaty until you meet this basic condition that both parties have signed and ratified the MLI. The second condition is that both contracting jurisdiction have listed the treaty between X and Y as a covered tax agreement. One of the elements of flexibility that the MLI offers is that countries are free to exclude some treaties from the list of covered tax agreement. For different reasons, a country may prefer to renegotiate because perhaps it's too old, the treaty is too old and they need to be updated in other provisions, perhaps. So countries are free to exclude some treaties from the list of covered tax agreement. But let's assume that in this case that X and Y have listed the covered tax agreement, the X and Y treaty as a covered tax agreement. The third condition is that neither X nor Y have made a reservation against the specific MLI provision that you are trying to determine if this is going to be applied or not to your treaty. So reservations are unilateral, but they prevent the provision itself from being applicable, from entering into effect with regard to your treaty. It depends on the text of the reservation, of course, if it's a general reservation against a particular provision, or if it is a reservation to exclude from the application of the MLI provision only some treaties and some provision with certain characteristics. Finally, and not in all cases, only when it is required by the MLI, you may have a fourth condition, which is to have a notification match. So if I told you that, explained to you that the MLI, in order to ensure certain level of certainty, requires countries to notify what provisions in the bilateral treaties will be affected or modified by the MLI provision. And sometimes the MLI requires to have a matching notification between two contracting jurisdictions for the provision of that bilateral treaty to be affected. In other cases, the MLI, the notification is merely for providing more certainty, but it doesn't condition the application of the provision, as it will be applicable and supersede the provisions of a bilateral treaty to the extent of incompatibility. And if those conditions are met, you will have a change ahead. When the change is going to happen, you have to apply the enter into effect rules in the MLI at the end of the MLI. And here it's over to you, Andrew, to continue.
Thank you very much, Nestor. We spent time talking about the MLI because one of the things that has emerged from the 3 Action 6 peer reviews that we've undertaken so far is that the MLI is by far and away the most effective way of implementing the BEPS minimum standards. If you look at the number of treaties that have now come into compliance, the MLI plays a very big part in that. And the reasons for that, I think it's obvious that it does take a long time, or can take a long time, to negotiate a treaty bilaterally. So the Action 6 peer review itself. Now this was set up immediately after the BEPS process, sort of the BEPS conclusions were put in place. In fact, the Action 6 report itself says it's going to be necessary to have a peer review. And if you remember what I said earlier about one of the things that you have to implement the minimum standard, but there's no particular time limit within which you can are obliged to do so. But that really means that we must have some sort of monitoring process, because you can't have countries just sort of kicking back and saying, oh, well, there's no time limit, I don't have to do anything. So we have this peer review mechanism in place. It was designed to be a light touch process. It's not one where the Secretariat is reading people's treaties and sort of hounding them and making them do things. It's really very largely a process which is driven by jurisdictions themselves, who are sent a questionnaire to respond to. And the questionnaire, we'll spend much more time looking at the questionnaire. But what you have to do under the questionnaire is to list all your existing comprehensive tax treaties. So we're not talking about air and shipping agreements. We're not talking about TIAs, tax information exchange agreements. We're not talking about limited agreements that only apply maybe to individuals. We're talking about comprehensive tax treaties. And so you list all those. You're also required to provide relevant information on the implementation of the minimum standard. And what we mean by that is interpretation and applications that might arise during the course of implementing the minimum standard, and also the difficulties in getting agreement from another jurisdiction. Because that, in many ways, that last thing, what I just said there, the difficulties in getting agreement from another jurisdiction, is in many ways the heart of the Action 6 process. Because you can list all your treaties and you can say they're all in conformity with the minimum standard, but if there's just a few treaties where you've not been able to get those get agreement because the other country has been dragging its feet, then that's the most important part, in my opinion, of the peer review process, that you can raise that issue, and it will be, if necessary, the Secretariat can sort of intermediate between the two countries and encourage them to resolve the differences. But if necessary, that issue can be brought to Working Party 1 for a discussion, and if necessary, that case can be reported to the inclusive framework so that those questions can be resolved. So that's the sort of the self-assessment part of it. And as I say, that most important that you use that process to raise difficulties in getting agreement if that applies to you. Something's come over my slide. There we are. Was that to remind me to get a move on? Probably. I will. The next stage in the process is that the Secretariat drafts a report they'll take, we will take all the questionnaires, the responses to the questionnaires, and we will compile it into a report, discuss with jurisdictions if necessary, and discuss it in Working Party 1, finalise the report and send it to the inclusive framework for their meeting in January, and when they will agree, or at least so far have agreed to those reports. So that's the way that the Action 6 peer review is structured. So the next slide talks about the way that, thank you. Next slide talks about the review of the methodology, because when the Action 6 minimum standard peer review was put in place, delegates decided at the time that the methodology would be reviewed in 2020. Now, it was a review of the methodology. It wasn't a review of the minimum standard. It wasn't a review of the terms of reference. So the minimum standards are still there. You have to do what you always had to do. And those 4 conditions, remember, that I mentioned in the terms of reference for the peer review, they're still there. You know, you only have to do it if asked. There are no time limits and so on. Those are still there. But what we changed was the methodology, and what we tried to do there was a process that was sort of more responsive to the needs of some countries. One of the things that we noticed, perhaps I shouldn't admit this, but it's true, that not all countries actually filled in their questionnaire, and they required considerable assistance. And hopefully this seminar that we're having today will help those countries who might be sort of intimidated by the questionnaire to fill it in. But what we really want to make sure is that countries do understand the possible vulnerability that their treaties have. Because remember, another country is not obliged to implement the minimum standard in its treaty with you unless you ask that other country to do so. Now, it may do so for its own reasons, of course, but you know, you need to understand that whether your treaty is potentially vulnerable to treaty shopping. So that's one of the things that we're trying to do here. If you look at the third bullet there, the revised methodology seeks to establish a framework to ensure more targeted assistance can be provided to jurisdictions to help them implement the minimum standard. And that will be including through the formulation of recommendations. There are no recommendations in the peer review report at the moment. We have some encouragements to jurisdictions, but in the future peer reviews, there will be recommendations. And one of them would be, if you've signed the MLI and you haven't got round to ratifying it, there could be good reasons for that. There could be not so good reasons. You will be recommended to go ahead and ratify. And of course, that's what you expect. You don't sign a treaty unless you're at that moment expecting to ratify it. So that's one of the recommendations. And the other recommendation that could be made to a jurisdiction is that if they're not sure, or they think that a treaty might be vulnerable, they will be recommended to put a plan in place in order to get that treaty, get the minimum standards incorporated into that treaty. And Sarah will explain much more of what we mean by that. So thank you for flashing up the agenda, Nestor, to remind me to hurry up. I think we're pretty much still on time, and we've got some time, I think, for questions and answers.
Yeah, and I will keep on the screen just the calendar, as I promised, of tax treaty and MLI related workshops in 2021 for you to have a glance at it. I invite you to register. We will, in those courses, we cover in much more detail the MLI, the substantive provision, the PPT and the examples and all that, for you to take advantage of this opportunity of having access to these virtual workshops, which is one of the positive effects, let's say, of the pandemic. We have turned all the calendar into virtual format, at least during 2021. Hopefully in the future, we will have a combination of both face-to-face and virtual events. But please register, and we can see each other again in one of those workshops in the future. So Sarah, please, I saw that you were very efficiently addressing some of the questions that we have received in the chat. So please, would you like to comment those, the answers to those questions?
Absolutely, and sorry for distracting you with my typing hand. So we received 2 questions so far in the chat. The first one asking us to confirm that if a jurisdiction chooses to implement the second component of the minimum standard by using the PPT and the detailed LOB, then no other specific anti-conduit rules would be required. So that's absolutely correct. And another question on the ways in which the MLI actually modify an underlying tax treaty, which I believe Nestor addressed, and I hope then that question has been, well, both questions have been answered to the satisfaction of those asking them. I've also in the chat included a link to the revised peer review document that contains a bit more detail on everything that we've just discussed in this session.